Hello and welcome to the Immigration Talk Show on IndusTV. I'm Rishi Khanna, CEO of Encore Consulting Services and National Consulting Group. And with us today we have attorney Poonam Bhuchar. Welcome.
I'm Poonam Bhuchar, Managing Partner of Bhuchar Law here in Lawrenceville, New Jersey. We practice corporate immigration law and represent Fortune 500 companies across the United States. We also are affiliated with Schaeferman Lakin that has 45 attorneys, and we basically cover every practice area possible.
So today we're going to be talking about corporate immigration compliance and the requirements by the government for the same. So Attorney Poonam, what are the requirements by the government for corporate immigration compliance, please?
So there are many requirements, but pertaining to immigration, it's mainly the PAF files, public access files. Once you sponsor someone on a H-1B, E3 visa, or a H-1B1, we also have I-9 compliance, and if your company has more than 50 employees, you're also subject to federal and state laws that need to be taken into account.
So are public access files and I-9 compliance requirements different? Because my understanding is that they're the same.
They are completely different. So public access files pertain to H-1B, hiring of H-1Bs, E3 visas, and H-1B1s. I-9 compliance is something that is required by all employers across the board. They're completely separate things. Public access files is to show that you are compliant with H-1B regulations, and I-9 compliance is to show that you're compliant with ICE regulations, showing that you have not hired any unauthorized worker.
Okay, so do we need a public access file for each employee that is on an immigrant visa?
Not every immigrant visa, so Ls don't require it. Again, it's H-1Bs, E3s, and H-1B1s. So a lot of the consulting companies need to have public access files because they hire H-1Bs, or a lot of the companies are H-1B dependent. And the public access file is something that a lot of companies don't give a lot of importance to because they just think it's a file, but the implications of that particular file are huge, and if a company doesn't comply, they can have several hundreds of $1,000s of fines for not being compliant.
So what exactly is the purpose of a public access file? What is in there?
The purpose of it is to ensure that you are abiding by H-1B regulations. And it's the first file that if the Department of Labor decides to audit you through a random audit or because an employee's complained, that's the first file that they will go and take a look at or ask for. A public access file has to be created within 1 day of the LCA being filed. And typically, the types of documents that are required in the public access file would be the certified LCA that's signed, would be the prevailing wage and the source of the prevailing wage. It would be the actual wage rate system. It would be the benefits summary, and also just if you have H-1B exempt employees, i.e. employees that are paid above $60,000 or have a master's degree, you have to keep a list of that in the public access file. And obviously, for one particular employee, you may have a number of public access files because you filed extensions or you filed amendments, or you filed more LCAs. So every single LCA needs to be in that public access file.
That's what I was going to talk about next, is how does the LCA notice tie into the public access file?
So the LCA notice, while it's a very archaic rule and doesn't really fit into modern day times of having the internet and being digital, it's a rule that requires you to post in 2 conspicuous locations at the place of employment. So what in a lot of the audits, in the internal audits and regular audits that we do, we've seen a lot of employers will file the LCA at their place of employment. So they'll file it in the kitchen, they'll file it in the notice board where employees can see it. But a lot of employers are still not filing it at the place of employment. So if your employee is at a third-party location, you are required to post it there. And if you don't post it there, that can have some serious implications. And proof of that posting needs to be in the public access file.
A lot of the clients do not allow such third-party postings. What are the workarounds?
The truth is, I've represented a number of clients at DOL audits, and there are no workarounds. The officers are very, very clear with what the law is. You have to send an email to the third-party place of employment saying that this is the LCA, can you please post it? If they refuse to post it, I've had DOL officers say flatly that you shouldn't be placing your employees there. And that's what I'm saying. It's a very archaic regulation that doesn't work with modern day times, but you're still required to comply with it. What I have seen though is as long as you make a good faith attempt and you keep copies of those emails in the file showing that you tried to have the LCA posted, sometimes they will give you a little bit of a break. It's still a violation, and it depends on the jurisdiction and the state that's auditing you as to how they fine you for not doing the posting.
Understood. Now, in this rapidly changing industry, projects come to an end and we get another project for our employee and we file an amendment. How does that affect the public access file?
So if you file an amendment, then you're filing a case with USCIS, and then you're filing a brand new LCA, and that LCA has to be placed into the public access file. If you're not filing an amendment, and this is the confusion with a lot of employers, if you're not filing an amendment and you're relying on a previous LCA because of the Simeo Solutions rule that they're within the vicinity of the LCA, you are still required to go and post that LCA at the new place of employment. It's not like you don't have to do anything, and that posting requirement has to be in the public access file.
If the employee moves location and if the H1 amendment is not filed, what are the implications on the public access files?
So you have to repost the current LCA that you're using at the new place of employment, even though you're not filing a case with USCIS, and that has to be documented in the public access file.
Okay, moving on to something more critical, which is the DOL audits. How do the DOL audits and the public access files tie in?
So they tie in, it's the file that makes sure that you're in compliance. And for DOL audits, it can be because an employee has complained against you or because DOL is doing a random audit. And we tell all of our clients that your public access file should be kept separate from the employee records. It just makes it easier. You can keep the public access files electronic, but I always recommend keeping physical files because technically even a member of the public can come and ask to see a public access file and you have to present it within a day. So rather than have someone have access to your computer system, it's easier to just take that file out and show them. So from a practical standpoint of view, you want the file separate. It's important because that shows that you've complied with the LCA requirements. It shows that you've complied with the prevailing wage. It shows that you have complied with the posting notices, and for each violation can cost anywhere from $1,000 to $1,500. And if one file has 6 or 7 violations and you've got multiple employees, you can see how quickly that adds up. And if DOL feels that it was willful neglect and you didn't comply, I mean, there could be criminal penalties, there could be disbarment of filing H-1Bs, which, as you know, for a H-1B dependent company, that can really paralyze a company's business.
Absolutely agree. Now, in this world of merger and acquisitions, what is the importance of public access files?
So we've done a number of mergers and acquisitions with companies where, unfortunately, we've been asked to come in at the last moment. So everyone gets so excited about the mergers and acquisitions, and they bring in the corporate attorney, they'll bring in the finance attorney, they'll bring in everyone. But you need an immigration attorney on board the minute you're talking about an acquisition. And the reason for that is because it's important for the immigration attorney to go through that company's public access files, see if they are compliant, and see what your exposure is. And if you want to continue the H-1Bs without filing transfers, you have to have a sworn statement in the public access file before the acquisition actually takes place in order for you to avail of that. And a lot of companies aren't aware of it. They'll sign the contracts not realizing that they are liable for anything that the previous company did or did not do.
So the liability of the current owner or the new owner is to keep the files current. It does not belong to the previous owner.
Well, it depends how the transaction is conducted, but in the same way, right, when you go to buy a car, you want to see what the value of it and you do your due diligence. The same way with the company, part of the due diligence needs to be what is the immigration exposure. So for instance, if your attorney comes in and they do the due diligence, and yeah, the company may be worth $10 million, but what if they haven't paid their employees' wages? What if there are back wage claims that could come in? You may be paying a value for that company that is overvalued versus if they have potential back wage claims. So it comes into assessing the cost of the company, the value of the company, as well as what the company's liability is before you take it over.
Now, jumping on to I-9 compliance, can you tell me how it is different than the public access files?
So I-9 compliance is something that is required across the board for every single employer. It's basically the I-9 form, and you have to fill it out within 3 business days. And every employer is required to do that for salaried employees to show that they've made due diligence efforts in order to show that the person that they're hiring is authorized to work.
So it is entirely different than a public access file?
It's completely separate and apart. And if you have somebody that is well versed in HR, they would understand the public access file component of H-1Bs and also I-9 compliance. Because at the end of the day, how that is maintained and how that is conducted is very important to how the company runs and what the company's liability is.
What are the pitfalls of an employer with I-9?
So there are several. So a lot of the times we see when we do internal audits is that a lot of the companies are not filling out the I-9s within 3 business days, which is a huge violation, and each violation again can be fined $1,000. So while it seems like it's just a piece of paper, there are some very technical requirements of it, and if you have substantive violations, the fines can rack up pretty significantly. So a lot of people do not fill them out within 3 business days. We've seen a lot of people will not actually look at the physical documents for the I-9s. They will take in scanned copies, and the requirement for an I-9 is to take the physical copies of list A, B, and C. It's up to the company whether they want to retain them. If you do retain them, you have to retain it for all employees, and you can't just pick and choose. We've seen companies not fill out Section 2 on time. We've seen companies have notaries fill out Section 2, and the notary hasn't filled it out correctly. And what people need to understand is that if your notary or somebody that you've authorized to fill out Section 2 doesn't fill it correctly, the company is ultimately liable for any fines that are associated with that. Another pitfall that we've seen is that a lot of companies are using the wrong edition of the I-9. That's considered a substantive violation, and the reason for that is with every I-9 edition that comes up, the list of documents may change for list A, B, and C. So there are a number of areas in which we've seen companies fail to comply with I-9s, and they're just not even aware of it.
Totally agree with you there. And who should be completing the I-9 forms? Is it the employee, the employer, or an independent attorney?
So Section 1 is filled out by the employee at the time of hire within 3 business days. Section 2 is filled out by the employer after Section 1 is completed by the employee. A lot of the time, Section 2, if somebody, so say there's a company in New Jersey, but the employee lives in Texas and has a project in Texas. A lot of the times, the employer may not have somebody that is authorized by the company to sign that Section 2, so they'll have a notary fill it in. But you need to make sure, or the HR in New Jersey needs to make sure that the notary has filled it out correctly, that they've looked at the documents. And the notary is not attesting the document, they're just saying and signing that they've physically taken a look at the documents.
So within 3 days of starting a job, or within 3 days of the offer being made to the employee?
Within 3 days of hire.
I-9 audit process, can we talk a little bit about the I-9 audit?
Yeah, I mean, it's very hard to go into detail with everything in the 20 minutes that we have, but generically, if you are audited by ICE, Immigration Customs Enforcement, you will receive a notice of inspection. That notice of inspection will ask you for your original copies of all the I-9s. You'll have about 3 days in order to present that to ICE. And it's important that you take those 3 days in order to hand over the I-9s to ICE. ICE will review them. They could come back with anything like a notice of discrepancy, that there are discrepancies in the I-9s. They could potentially give you 10 days to fix some of the I-9s. They may issue you a notice of suspect if they feel that you've hired unauthorized workers. Basically, from the moment of the notice of inspection is the time you should have an attorney involved, because where the additional notices that you get will be dependent upon the state of your I-9s. And we've seen companies potentially face fines of hundreds of thousands just because of a piece of paper. And it's not just a piece of paper, it's something that where you are attesting and showing the government that you've taken all due diligence efforts to make sure that you're not hiring an unauthorized worker.
Fair enough. I do want to go back to the contents of the public access file. If we can quite explicitly list what should be in a complete public access file for the benefit of the listeners.
There needs to be the certified LCA with a signed copy of the certified LCA. There needs to be the prevailing wage and the source of how the prevailing wage was obtained. There needs to be an actual wage rate system as to how you came about that. What was your procedure for coming to that particular wage, based on education, experience. Our office has a template that we give our clients. We also need to have the benefits that you offer the employees, and obviously the benefits should be the same for US citizens and H-1B workers so that you're not discriminating against anybody. We also should have in there your list of exempt H-1B employees. So when you file the LCA, you file that a lot of the times as exempt because the salary is over 60,000 or they have the equivalent of a master's degree. You need to have a list of those employees because exempt employees aren't subject to additional LCA attestations. The other thing that I want to point out, where I've seen employees get fined and employers get fined and failed, is a copy of the LCA needs to be provided to the H-1B worker, and you should have something signed in the PAF file where the H-1B worker is signing and attesting that they have received a copy of the LCA. That needs to be in there as well. Also, generally somewhere in the generic vicinity of the PAF files, your recruitment efforts to hire US workers.
So that was a fairly comprehensive exchange of information, and definitely enlightening and information filled. We will now move on to questions by the audience. Here is the first question.
Hi Poonam, this is Anjali, and my question is related with public access files. Just want to understand, how many years should we maintain these public access files once an employee exits the company?
So that's a great question. The public access file should be kept at least a year from the end of the LCA date if the employee is still working for you, or if the employee has been terminated, at least a year from the date of termination. And obviously, if you're in the middle of a DOL audit, then they shouldn't be discarded at all.
Okay. Here's another question.
Hello, my name is Vishali, and my question is, due to the COVID-19 pandemic, are there any change in policies that we need to follow while completing the I-9 form?
So another great question. During COVID, as of March 2020 last year, US ICE gave some leniency with regards to I-9s for people who were working remotely. You were allowed to just have the documents scanned, looked at, and you could complete the I-9s. They've done a series of extensions. The latest extension goes until May 31st, 2020. However, employers need to remember that the moment the employees come back on site, they need to physically verify and complete the I-9s.
You mean 2021?
Yes, I'm sorry. It started, the extension, the leniency started in March 2020, and through a series of extensions, the latest extension is until May 2021, and May 31st, 2021. We're not sure if they'll extend it again, but that leniency is there where you can review the I-9s through scan, or some people have been doing it over Zoom. But the minute the employees come back to the physical place of work, the I-9s have to be verified physically, the documents do.
So today we covered a lot of topics, public access files and its importance, and also the I-9 files and their importance. Attorney Poonam is here for any questions or help that you might need in your business to make sure that you're in compliance, for it's very important and critical, and she is always here to answer any questions and help you guys.